Hi everybody, welcome to the IP Flow Show. I'm Anna Sophia Walsh. My guest today is Ed Timberlake, board certified specialist in trademark law and trademark attorney. He was also a former trademark examiner at the USPTO and at the US Copyright Office. Welcome to the show, Ed.
Thanks very much for having me.
So the topic of the day is distinctiveness. You would like to speak a little bit on the importance of distinctiveness in comparison to the lawsuits that have been happening over trademarks that aren't necessarily overly distinguishable.
Yes, I find that there's a lot of attention paid to people suing each other in the trademarks area, and a lot of attention paid to cases that are long, drawn-out, expensive cases where the marks themselves are just not particularly distinctive. So I feel like that area is covered really, really well. What I sense is that we don't actually spend time in the profession discussing what distinctive marks are and sort of emphasizing. It seems like it's sort of a squeaky wheel getting all the grease problem. And plus, I think from a very practical standpoint, if you're talking to clients, I don't speak to clients all that often who come in and say, hey, we'd really like to get into a lawsuit. You know, usually it's somebody who's in business and they would like to stay out of a lawsuit. So I just thought it would be timely to bring up the issue of just sort of emphasizing this often overlooked element of trademark law.
Would you like to give a bit of background on the importance of the distinctiveness?
Yeah, well, in my view, and certainly people come to this from different perspectives, but in my view, the whole point of the Lanham Act, the big federal statute that deals with trademarks and sets up the registration mechanism, it seems to me that the whole point of setting up the registration mechanism is to encourage, is sort of to push people in the direction of saying, look, if you're out there and you're using something as a trademark, you know, before the Lanham Act comes along, you've got some protection for your trademark. It's a little less clear and it's a little harder to prove, but there were protections before the Lanham Act. So at least as I see it, the Lanham Act is there to say, look, if you want better legal protections, if you want clearer legal protections for what you're doing, then just move over here in this direction of being a little bit more distinctive than you might otherwise be. And the motivation is that, look, you get this very significant legal boost, but what you have to bring to the party is trying harder with making what you're doing, what your symbol is or your logo is, different than what other people are doing.
Sure. And do you have any examples of particularly strong trademarks that you believe are quite distinctive as opposed to some of these weak trademarks that are embroiled in lawsuits?
Well, I think maybe a better way of, or I might turn that around a little bit and just say that I think even calling something strong is a little bit misleading, that I think we would do better if we emphasized just all of the time, emphasize the context, how important the context is, that something that might, you know, particularly like a particular word, might make a very strong trademark for certain things in a certain market, but be an incredibly weak trademark for other things in a different market. And so I think rather than focusing even on whatever the actual element is, I think we would do well to constantly remind people of what the context and how context-specific all of the trademark analysis is. So I think also I would like to see, as a profession, I would like to see people who are doing trademark law work just emphasize more the importance from the very beginning of just going in a different direction. Because oftentimes, if for a small business, I deal with a lot of small businesses, oftentimes for a small business, they're not going to have a budget, a big legal budget for a lawsuit. They're not necessarily even going to have a big legal budget for a prosecution. But for a fairly small amount of money, you can get some advice, you can get some sort of orientation to say, look, if you're going into this market, then these are some trademark mistakes that are easy to avoid. And really sort of pointing out the fact that from a lot of the hard work that goes into trademark work the person can do themselves, that they can sit down. It often comes down to naming or coming up with a logo, and I think anybody who's had to do any naming at all can tell you just how difficult it is. It's really, really hard. So to come up with something that sounds good, that matches what you're doing, and is going to be something that will be easy to get through the trademark registration process, that's really tricky. And I think that we ought to get the word out to people earlier so that I think everybody knows, well, you got to check for social media site availability, you got to check for domain availability. In my opinion, and I clearly have a slanted view on this, but in my opinion, before you're doing any of that, you should be thinking about, okay, is this going to be a good candidate to take to the trademark?
Absolutely.
And I think also one thing that I think people often will tag the trademark analysis on the end of all of the rest of what they're doing. They'll come up with sort of an image, and maybe they'll have some things printed, and they'll sign up for some accounts. And then they come to me, kind of last in the process, like, okay, now we're ready to make this official. Can you take it? And at that point, oftentimes you can just look at it and say, no, this is going to be a disaster. But because that conversation happens so late in the game, often, then I look like the bad guy who's saying,
yeah, that's a bad idea or something.
Right.
Yeah.
So I would also love to try and figure out a way to get some of the legal discussion in at the very early part of the process, rather than thinking of it as something that's at the very end.
Well, do you think there's an increased awareness of branding nowadays? I feel like you said, in small businesses, there isn't always a budget for, prosecution or lawsuits, but I feel like there is more of an awareness that you have to put a lot more thought into your brand because of these petty lawsuits.
Well, I think, yes, I think there does seem to be an emphasis on awareness of the overall image for whatever you're doing. And that's good, but I just think that the lawyers involved in this process, that we can do better in terms of kind of setting people in the right direction or setting people on the right track, because we still, amongst ourselves, use a lot of the language of property. We refer to this as, trademarks as intellectual property, which I don't think even really makes sense in the context of trademarks, but whether it makes sense or not, I just don't think speaking of these things in terms of property is very helpful, because people immediately, it just comes with all of its own sort of connotations and its own imagery, and I think we teach them to think about this in a property mindset, and in that way they're sort of like, locking things down and building a wall to block people out and defending their property. Whereas, at least as I see it, the main benefit particularly for a small business, the main benefit that a really distinctive mark can bring you is that it can be a pretty cheap way to set yourself apart from people who are bigger and have bigger budgets. But if you try to play if a small entity tries to play the property game, the owning, I'm going to shut other people out kind of thing, with somebody bigger, it seems that very often they're just going to get clobbered.
What do you advise your clients, especially if they come to you with descriptive trademarks, that at that point you shut down the process, or are you still prone to continue with the trademark application process?
Yeah, I think that, and I will say that that's one sort of uncomfortable element of this, is that I think that to give businesses responsible trademark advice has to mean that you're talking a lot of people out of filing for things, because they just, very often somebody's first draft or first 5 drafts of what they think they'll go with wouldn't be good candidates for the trademark process. And then that's also another thing I think that we don't convey very well to businesses, is just the fact that not everything is going to be a good candidate for registration, and most of that process is pretty knowable. I mean, you have generally a pretty good sense of whether something's going to sail through the process or whether it's going to be held up at each point. And I find that often we don't adequately convey how much more expensive a crappy mark is going to be ultimately. And it's not going to really benefit the business at all. Plus, it's going to face a lot of legal hurdles, or very likely face a lot of legal hurdles. So really, rather than us sort of commodifying the filing as, oh yes, sure, we'll just, bring us anything and we'll file it, I would like to see a little bit more movement in the direction of, hey, what you're actually getting here, by talking to a lawyer at all, what you're getting and what you need is the counsel, is the sort of advice of somebody to look at what you're doing and say, that's not going to be, not only is that not going to be a great candidate for registration, but whether or not registration is an issue, that's just not going to set your business apart in a way that something else could.
So there needs to be a bit more cooperation with the business and the legal counsel, basically.
Yeah, I'd love for us to be more involved, and I haven't figured out how to do this yet, but to get a little bit more of this voice, particularly, this probably wouldn't work in every field of law, but when you're talking about trademark lawyers, I would love to have more of that input, at the time that you're sort of brainstorming branding ideas and brainstorming other ideas, just to say, look, there are a few things that, because depending on what the field is, there are often some sort of obvious areas obvious mistakes. Well, I don't know if I won't necessarily want to say mistakes, but human beings have this, I think, we're really good at figuring out what other people are doing and doing something very similar to that. Sort of on an evolutionary basis, I think that makes sense, that, if you're sitting there and everybody starts running away, and you look up and you see, it's like, okay, well, it makes sense I'm going to go, I don't even know what's going on, but I'm going to run away now too. For millions of years, that's been a good idea. But I think that when it comes to business, you're having to fight against that impulse. You're having to go, like, wait a minute, I see what other people are doing, I see what the sort of norms in my field are. And from a trademark standpoint, it's worth the extra effort to go completely in the opposite direction, or at least try to go in a different direction.
Sure. A very interesting insight there. Thank you very much for coming on the show, Ed. It was a pleasure speaking with you.
The pleasure was all mine. Thanks.
Thank you. And that was Ed Timberlake. If you'd like to check out more of the stuff we're working on, please check our website out on mimesislaw.com/IPflow. Follow us on Twitter and Facebook, and subscribe to this channel. That was the IP Flow Show, and I'm Anna-Sophia Walsh. Thank you for watching, and see you again next time.
We're dealing with a variety of macroeconomic forces and also some particular things that are happening in the legal community to put all these cases in front of the Supreme Court. But it also feels like we're talking about this an awful lot. Is our society reassessing how intellectual property rights should be handled? Is this a recalibration?
I think it is in some respects. I think you had situations where people who were being under attack, so to speak, from the people asserting patents have felt that